This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Supreme Court decided unanimously in favor of Donald Trump on Monday, ruling that states can't kick him off the presidential ballot using Section 3 of the 14th Amendment, the provision barring insurrectionists from holding office. Trump thanked the court.
They worked long, they worked hard, and frankly, they worked very quickly on something that will be spoken about 100 years from now and 200 years from now. Extremely important.
The unsigned per curiam opinion mirrored the concerns expressed by the justices during oral arguments about state-by-state determinations of the disqualification of a federal candidate. Here's Justice Elena Kagan.
I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. In other words, this question of whether a former president is disqualified for insurrection to be president again is, just say it. It sounds awfully national.
On the surface, the court was unanimous. But just below the surface, there was plenty of division. The three liberal justices wrote a bitter concurring opinion, which reads more like a dissent, saying the five conservatives had gone too far in the opinion when they said that legislation was required to implement Section 3. And even conservative Justice Amy Coney Barrett agreed with the liberals, but wrote her own, more restrained concurrence. Joining me is Jessica Levinson, a professor at Loyola Law School and host of the Passing Judgment podcast. Jessica, explain the basics of the per curiam opinion.
The top line here is that 9 of the justices agreed that when it comes to a state, they do not have the power under Section 3 of the 14th Amendment for federal officials, particularly for the president, to say that they're disqualified for office having been previously serving in government, engaging in insurrection, and then trying to once again serve in government.
The three liberal justices, in their concurrence, which read like a dissent, said that the five conservatives in the majority went too far. Quote, they decide novel constitutional questions to insulate this court and petitioner, that's Trump, from future controversy. What's their real concern there?
So I think what the concurrence, which really does read more like a dissent, is concerned about is, one, that the court answered a question that wasn't asked. That they said not only can a state not by itself say that there's a federal candidate who's ineligible for office under Section 3 of the 14th Amendment, but here's who can. It's just Congress, and it's just through a certain type of legislation. And so the first problem the concurrence has is this idea that, in fact, the per curiam, and as they phrase it, the majority, is just going too far. And they're answering a question that they didn't need to, and that violates the principle of judicial restraint. And then the second thing they're saying about insulating, and I think this wasn't clear, and I wish they had just said what they mean, but I suspect what they mean is that by the majority saying, here's the way that you enforce Section 3. It's congressional legislation, narrowly tailored, that is specifically aimed at the issue that the Constitution lays out. That what they're saying is, does that mean then if Donald Trump, for instance, was to win the election and then Congress was to try not to certify under a different statute, under the Electoral Count Act, would Congress then lack the power to do that under this majority opinion?
And during the oral arguments, the lawyer for the Colorado voters had said that a rule requiring congressional action to implement Section 3 could leave the door open to a renewed fight over trying to use the provision to disqualify Trump in the event that he wins the election. So those five conservatives knew what they were doing.
I think the conservatives did know what they were doing. This was discussed in oral argument. I think that there's a question as to whether or not it's appropriate or not for the per curiam to have gone further than just Colorado lacks this power. But it certainly is the case that there was a conversation about whether or not a specific type of judicial decision would just kick the can down the road. And I think that's what the concurrence by the liberals is really arguing here, which is you're just pushing off some big and complicated questions until later. And specifically, those big questions, you're actually tilting the scale in favor of saying that Congress would lack the power to take any action outside of a new piece of legislation, and that's helpful not just for Trump, but for the court itself in avoiding future controversy.
There was obviously a push to speak with one voice on this critical issue, but if this were a different, let's say, low-profile case, these concurrences would probably be dissents. So was this really a unanimous decision, or was it just dressed up to look like one?
It really was a unanimous decision that was deeply fractured on everything else other than the one line of the outcome. So on the one hand, you can see that there's this enormous pressure because it's a case with huge political consequences and huge consequences on an issue that really divides our country, that the court not look like they're policymakers, that the court look like they are judges, they are resolving disputes, they are not putting their thumb on the scale of an election. And so I think that's how we do get to that one line saying, based on federalism, based on all of these concerns about patchworks and chaos, we're going to say Colorado went outside of its power. But then the agreement dissipates, and that's where we lose all consensus. And that's where you have the majority, I think, taking a very different stance, saying, and here's exactly how you apply Section 3, and the concurrent saying, why are you going so far? And you're doing this in a way that not just avoids judicial restraint, but you're kind of tipping the scales in favor of somebody like the former president.
Justice Barrett, in her separate, more temperate concurrence, wrote that with a politically charged issue like this, writings from the court should turn the national temperature down, not up. But then goes on to say, well, the main message is we all agreed.
Right. And I think this is an understandable message by Justice Barrett because she's very cognizant of the fact that she doesn't want this to be a Bush v. Gore redux, where it looks like by a thinly divided court, divided along ideological lines of who appointed the justices, that they make a decision that has a huge effect on the presidential election. So what she's saying is she understands the concern that the majority went too far, but she wishes that, I think the the Freudian slip, that the concurrence hadn't used such strident language. And I wonder if there was some world in which the liberals actually could have gotten Justice Barrett to sign on if the tenor of the concurrence had maybe been slightly different.
Well, Barrett hasn't been sitting in those liberal seats for years, particularly Sonia Sotomayor, and, probably building up a lot of frustration dealing with the super conservative majority. Is Barrett on a sort of a mission? Because she appeared with Sonia Sotomayor at the National Conference of Governors to say there are not Republican judges or Democratic judges. We all wear black robes, not red, not blue. Is she on a mission that you usually see the chief on?
I think that it's Justice Barrett, it's Justice Sonia Sotomayor, who's also spoken warmly about Justice Clarence Thomas. It's the Chief Justice, it's Elena Kagan, all of whom have said some version of, please know that we're judges, not politicians in robes. And of course, they need that, right? The Supreme Court depends on our respect, and it depends on us viewing them as something different from just political actors, because ultimately they get their power from us saying that they have that power. I mean, they don't have an army to send in. They don't have a group of police officers to send in to enforce their opinions. They have the power of the pen. And if we ignore that, then we have a real problem with our third branch.
So they don't want to be seen as political actors. They want to be seen as judges. Yet in the space of 5 days, they gave Trump this outright victory in Colorado and an indirect victory by keeping his criminal trial over election interference on hold while they decide whether he has presidential immunity from prosecution, which may mean, probably will mean, that he won't be tried in the election interference case before the November election. How is that not political?
I think what the justices would say is, look, we decided to take this case because we decide big constitutional questions that are matters of first impression. And this is a big constitutional question that we've never confronted before. And they might also say, Jack Smith came to us in December and asked us to set this for arguments in March. We instead said, you don't get to jump the line, and we set arguments for the end of April. Now, is the end of April quite different, in fact, when it comes to the court calendar and the electoral calendar than the beginning of March? Of course it is. But they might say it's not our responsibility to make sure the case can occur before the election. Now, on the other hand, of course, one would say, well, are they actually unnecessarily delaying things by setting this particular pace? But I think the justices would say, actually, we're moving for us quite quickly.
Well, they set it for the last possible day they could for oral arguments.
And what we do need to think about is that we could get a decision that isn't just an up or down. It's not just there is absolute immunity or there isn't. We could get a decision that says, for instance, there is qualified immunity, and send the case back to Judge Chutkan, the trial court judge in the D.C. case, and tell her to apply that standard. That could also present a delay. There's also another question looming in an unrelated case before the Supreme Court dealing with whether or not the federal statute that Trump is charged under, at least for I think half of the charges, whether or not that's appropriate to use in this type of case. And that similarly could have delayed this trial.
Well, the delay strategy is certainly working for Trump. Thanks so much, Jessica. That's Professor Jessica Levinson of Loyola Law School. Coming up, the 11th Circuit stops part of Florida's Stop Woke Act. I'm June Grasso, and you're listening to Bloomberg.
We fight the woke in the legislatures. We fight the woke in the schools. We fight the woke in the corporations. We refuse to surrender to the woke mob. This state is where woke goes to die.
Or maybe not. Despite what Governor Ron DeSantis says over and over, actually, it's the courts in Florida where his anti-woke laws go to die. Many of his most controversial laws have faced legal roadblocks. The latest is his ban on so-called woke company training, which restricts how private employers can train their workers. On Monday, the conservative 11th Circuit unanimously blocked that ban as unconstitutional for committing, quote, the greatest First Amendment sin, penalizing speech based on viewpoints. Joining me is leading First Amendment scholar Eugene Volokh, a professor at UCLA Law School. Eugene, can you tell us what this particular anti-woke law is about?
Sure. So this case involves a particular portion of the Florida law that's called sometimes the Stop Woke Act. Doesn't deal with other portions having to do, for example, with colleges and universities and the like. Has to do with its restriction on employers, including private employers. And that restriction prohibits employers from subjecting people as condition of employment to training, instruction, or other such activities, required activities that, among other things, promote a certain set of beliefs. And those beliefs include things like members of one race, color, sex, or national origin are morally superior to others, or a person by virtue of his race or national origin is inherently racist, sexist, or oppressive, or that a person's moral character or status as privileged or oppressed is necessarily determined by race, color, sex, and the like. So there's certain particular viewpoints that private employers are not allowed to include or to teach as part of compelled instruction for their employees.
I mean, is there any private employer teaching that one race is superior to the other or any of the other things?
Well, I'm not sure about the superior, but my understanding is that some supposed diversity, equity, and inclusion instruction does talk about how, well, white people are privileged, whereas non-whites or especially blacks are oppressed, or that whites are inherently racist and that whites should be viewed as oppressors. There are other things the law also includes, like that members of a particular group cannot and should not attempt to treat others without respect to race, color, sex, or national origin. My understanding is that some forms of instruction do indeed say, look, it's impossible for us to be colorblind either in general or it's impossible for whites to be colorblind. Another item that's covered by the law is that they can't teach that a person bears responsibility for or should be discriminated against because of actions committed in the past by other members of the same race, sex, national origin, and the like. Well, there too, I think some trainings do suggest that race-based affirmative action is justified because whites in the past have oppressed blacks, let's say, and therefore there needs to be compensatory preferential treatment and discrimination now because of that.
The opponents of the law sued over its effects on free speech, so basically just saying it was a free speech violation.
Yes, that's right. And in particular, they said, look, this law is viewpoint-based. It doesn't just, for example, prohibit employers from having mandatory education sessions that talk about politics of any sort. Rather, it singles out particular viewpoints as being prohibited in these kinds of education programs. And the court says that viewpoint discrimination is the hardest to justify, most likely unconstitutional form of speech restriction, and that the law indeed unconstitutionally discriminated based on viewpoint. And the 11th Circuit panel agreed.
Florida argued that it was regulating employers' conduct, not speech. And the court said, we reject this latest attempt to control speech by recharacterizing it as conduct. Does that happen often as a defense in these cases, saying it's conduct?
Well, yeah, I think the government often tries to do this. Sometimes, for example, laws that ban sexual orientation change therapy for children have been justified as bans on conduct, even when the therapy involved only basically speaking to the person rather than administering drugs and the like. Likewise, some other laws that ban supposed cyber stalking, but cyber stalking in the form of unwanted speech about a person. There sometimes are laws or injunctions that say, look, stop talking about this person, have been justified as restrictions on conduct. But the court here says that's not going to fly because the only conduct here is conveying certain viewpoints. If, for example, the law said, well, you can't require people to be at work before 8 a.m., let's say. Well, okay, that would not be a speech restriction. That would be a conduct restriction. Various kinds of laws regulating the employment relationship are conduct restrictions. But where the law says, look, these are particular ideas, particular opinions you cannot teach people, well, that's all about the speech, all about what the employer is communicating, and therefore it's a speech restriction.
Did anything in particular in the opinion stand out to you?
I think it was a pretty forceful repudiation of this kind of viewpoint discrimination. I will say there was one thing in particular that might be relevant for future cases. One thing that Florida said in defense of the law said, look, there are all of these rulings about hostile work environments and supposed racial harassment, where employers can be held liable for racially offensive or sexually or religiously offensive speech, even by their employees and especially by the employer itself. So there have been lawsuits, for example, over people playing offensive and supposedly misogynistic, perhaps even actually misogynistic rap lyrics, or claims that it was racial harassment for people to say things that are potentially racist, even if they're kind of political expression. So Florida's argument was, look, it's established that it's okay to restrict that kind of speech. Well, we want to restrict speech that may create a racially hostile environment through these forms of mandatory training. And the court said, well, Title VII is different, part of this broader anti-discrimination law. But beyond that, even Title VII, even these kind of racial harassment and sexual harassment principles, there are valid concerns about how they collide with the First Amendment, and that courts therefore must exercise special caution when applying Title VII to matters involving traditionally protected areas of speech. So I do think that might be helpful for the future when it's sort of anti-woke or non-woke speech that leads to a lawsuit. This may well be cited to say that, well, that is protected by the First Amendment and the government can't impose liability for it.
So did the court use the highest standard of review, strict scrutiny?
Right. So the court said, look, this is content discrimination, but even worse, it's viewpoint discrimination. Viewpoint discrimination is generally unconstitutional. Maybe it might be constitutional if it passes this exacting standard of strict scrutiny. But it is rare that a regulation restricting speech, even because of its content, much less its viewpoint, will ever be permissible, the court was saying. And the court said in this case, it doesn't pass strict scrutiny. There's no compelling government interest in suppressing this kind of speech.
The press secretary for DeSantis said they're reviewing all options for a potential appeal. One of those options would be the Supreme Court. Do you think the Supreme Court would want to weigh in on a case like this?
It's possible. The Supreme Court does take a considerable number of First Amendment cases because it thinks that First Amendment rules are particularly important. I think it's pretty unlikely just because even in cases where a state challenges a finding that a law is unconstitutional, the court usually prefers to wait until there's a split of authority in lower courts, a circuit split, where, say, the 11th Circuit strikes down some law and, say, the 8th Circuit upholds a similar law or uses some legal analysis as inconsistent with the 11th Circuit's decision. That's sort of a signal to the court this is an important issue, it's likely to recur, lower courts are in disagreement. Usually when there's kind of a one-off state law, in which there aren't really a lot of others like it, and certainly no appellate decisions dealing with it, when that gets struck down, that usually doesn't lead to Supreme Court review, but it's possible.
I mean, how big a victory is this for free speech coming from a conservative appellate court? Noteworthy?
Right. Yeah, it is noteworthy because it's a reminder that First Amendment provides very strong protection against viewpoint discrimination by the government. And that applies, again, whether it's discrimination against woke viewpoints or against anti-woke viewpoints. That generally speaking, the government cannot restrict speech based on viewpoint, even when the viewpoints have to do with highly controversial matters such as race and sex and national origin, and even when the viewpoints are offensive to many.
Thanks so much for your insights, Eugene, as always. That's Professor Eugene Volokh of UCLA Law School. Now some other legal news. Sam Bankman-Fried, remember him? His spectacular fall from grace and trial for masterminding a multi-billion-dollar fraud kept him in the headlines for months. But since his conviction last November, things have been quiet for SBF, at least in the media. But behind the scenes, he's been preparing for his sentencing and appeal, most notably by shuffling lawyers and, with help from his parents, flooding the judge with letters pleading for leniency. Joining me is Bloomberg legal reporter Chris Domesh, who's read all the letters. Chris, how long could the judge sentence him to?
So obviously, there are a lot of factors at play here, given the seriousness of his conduct and the number of charges he was convicted of. But I talked to a lot of defense attorneys about this, and he's going to get probably at least a decade in prison, which is, a lot of time for a person of his age, but it's kind of reasonable given what the sentencing guidelines call for him to serve, which is a life sentence, essentially, given the size of the loss in the case. But anybody who follows the criminal justice system in America, especially the federal system, knows that white-collar sentences, which are driven by monetary losses, the proposed sentences under the guidelines are really, they're draconian. So 25 years is probably a little bit on the higher end, but the judge himself in this case, Louis Kaplan, has issued skepticism about the guidelines in the past, especially in white-collar cases where the loss amount is very high. And if you look back at some of the cases that he sentenced, he doesn't tend to throw the book at people. He's obviously a tough judge. He gave SBS defense team a hard time during the trial, but he seems to be sympathetic to the argument, at very least, that throwing him in prison for the rest of his life is really not going to do society or him any justice.
And he's gotten a new defense attorney, Mark Mukasey.
Yep, Mark Mukasey, very well known in the Southern District of New York. His father's former U.S. attorney. He's a former federal prosecutor in the Southern District. He's represented many white-collar clients. He's a passionate advocate for his clients.
He represented Nikola founder Trevor Milton, who was sentenced to only 4 years in prison when the prosecutors asked for 11 years, so quite a difference. And here, Mukasey is asking that SBF serve no more than 6 years. That's on the very, very low end, isn't it?
Yes. They couldn't have really logically argued for less. And, their arguments are that throwing him in prison for the rest of his life doesn't really serve the purposes of justice, especially for somebody who, despite the fact that he's a convicted felon, arguably has a lot to give in terms of his contributions to society. And Mark Mukasey and others have made the comparison to Michael Milken, who, was very young when he was convicted and managed to build up a life of philanthropy, which is really what SBF, that's what they talk about in these letters, that he is devoted to philanthropy. That's the whole driving force of his life.
It's going to be interesting to see how much time the prosecutors ask for. Thanks so much, Chris. That's Bloomberg legal reporter Chris Domesh. Coming up, a $6 billion legal bill and the senator who likes to trip up judicial nominees. I'm June Grasso, and you're listening to Bloomberg.
The best things in life for free, but you can give them to the birds and bees. I want money. That's what I want. That's what I want.
Yes, they want money. $6 billion of it. That's how much the lawyers want for their services in getting Elon Musk's $56 billion pay package thrown out. Oh, and they'll take those legal fees in Tesla stock, please. The irony is they argued that Musk's pay package was excessive, and now they want their unprecedented $6 billion legal bill paid. And the kicker is that legal bill may be payable in full under Delaware law. Joining me is business law expert Eric Talley, a professor at Columbia Law School. $6 billion in legal fees, that would be an hourly rate of $288,888. I mean, where are they getting that from?
Well, once again, June, you and I have chosen the wrong professions, it appears. But so here's
Is it
where they're
too
getting
late?
it from. I don't know. It's never too late. One can always dream. But here's where they're getting it from. First of all, realize that the outcome of the case was phenomenally large as well, right? $56 billion, in terms of a compensation package that is essentially then being clawed back. And so the way that this case gets set up, as well as pretty much all shareholder litigation, is that it is brought on a contingency fee basis, which means that the lawyers are going to basically self-finance the entire action until they get to the finish line of either a settlement or, in this case, a judgment, an outcome. And only then are they in a position where they can try to petition the court for an award of attorney's fees. And so essentially, you can almost think of the law firms that bring these actions as almost being like venture capital funds, right? They invest in a bunch of different projects, different lawsuits. Many of them are going to be losers. Many of them are going to either settle for nothing or they'll just have to be dropped. And then other ones will pay off. So it's kind of a high-risk, high-reward thing. And so it is often the case that when there is one of these cases that ends up resulting in a substantial judgment that can be monetized, and this one is one, the contingency fee looks in hindsight like an outrageous amount of hourly compensation. But one also has to think about how to set that off against a bunch of other factors, including risk, including cost, including effort, including the hard aspects of bringing a case of this type of complexity. And so when you sort of back those out, most of the time these contingency fees end up looking a little bit smaller on an hourly basis because you've essentially had to control for all the high probabilities that there was going to be nothing at the end of the rainbow here. So that's one of the factors that really controls any situation where there's a contingency fee award when it's not structured as an hourly rate. Pretty much all of these plaintiff shareholder litigation fees are based on some type of a contingency arrangement.
I know Delaware courts have allowed hundreds of millions of dollars in legal fees in stockholder actions. How do they assess these contingency fees?
Over the years, the courts have come up with sort of a formula for thinking about when and under what circumstances a contingency fee should be awarded and how high it should be. What percentage of the total award should be paid over to the attorneys. And there's a long-standing line of cases. The most recent ones are within the last couple of years that basically say, look, there's several factors that we look at. One of the factors we look at is, the value that is created for shareholders. And, I guess one lens of this, you could say, well, this was $56 billion worth of value that was created to shareholders because those Tesla shareholders were able to claw back a $56 billion stock award payment that they would have had to share, and now they don't have to share it. A couple of the other factors that go into it is, how risky was it? How costly was it? What's the reputation of the firms that are bringing this? Are they kind of ambulance chaser type firms? Are they sophisticated sort of firms? The thing that was kind of odd about this case is that when you went down these factors, the factors all seemed to point in the plaintiff's direction, right? This was a fairly substantial award. It was risky. It was costly. Bernstein Litowitz, who was lead counsel on this, is one of probably the most sophisticated and high reputation plaintiff firms in the country. And so typically what that would mean is that when you get to the end of these factors, which the petition for fees went through them one by one, if you check all the boxes, make it to the very finish line, then the typical norm in Delaware is to award something like a third of the award to the attorneys. Now, that would have been about $18 billion. And so I think that the attorneys, when they're drafting this, sort of said, okay, that's just a big number. And so they kind of make a point of saying, look, we're going to articulate all these factors. We're going to say that under existing law would entitle us to a third. We're going to take a third of a third, or 11%. And that's where they ended up at their $5.8 or $5.9 billion request.
But does it not seem ironic that they argued that Musk's pay package was excessive, and now they want a chunk of it, also excessive?
Yeah, it's kind of an interesting thing. I mean, I guess you could run this in multiple directions, right? One is to say the pay package was so excessive that when we prevailed, this is what the plaintiff's attorneys would argue, that when we prevailed on having it nullified, we created an excessive benefit to shareholders, that $56 billion benefit. So had the pay package not been as exorbitant, then our fee would not be as large. And we are then once again doubling back and saying, and guess what? We're going to take only a third of the fee that under the sort of the cookie cutter approach we would presumptively be entitled to. The fact of the matter, though, is you're right, June, that this is a gargantuan award. A lot of times you'll see big fights over attorney's fees that are in the hundreds of millions of dollars, $300, $400 million. But one of the big challenges in this case is that the $56 billion award is kind of the denominator against which all this other stuff is measured, right? And we just haven't seen a $56 billion award that has put itself in this position where we're trying to figure out what's the value of the attorney's fees. And, there are cases recently that have tried to contend with this question of, as the award gets bigger, should the percentage go down? And the Delaware courts have generally resisted that thus far, but that could factor into Chancellor McCormick's assessment of the fee request.
Elon Musk may not be getting that $56 billion pay package, but they have to redo his pay package, right? So Tesla won't be keeping all of that $56 billion.
Well, that, I think, really is the $56 billion question, June. The pay package itself was nullified, which basically means that Mr. Musk was working maybe not quite for free, because remember, he owned 22% of the company. So any, $10 billion increase in the value of the company is going to give him $2 billion worth of value that he has already pocketed. But I think, one could sort of kick this case around and try to think where are the ways that it might have come out differently. I think one area that it might have come out differently is exactly on this point about whether if the pay package is being nullified, does that mean that he's entitled to nothing for the services that he provided to Tesla over these years under the presumption that he was going to be paid from this executive compensation package? And so that itself is a type of a claim that you will often see in cases where a contract gets nullified. It said, look, if you're not going to let me collect pursuant to the contract, let me at least make out a claim of what was the benefit that I conferred on the other side, and we can come up with fair terms. And so that argument, for example, might end up culminating in a finding that the fair value of what Musk created for Tesla was, $30 billion or something like that. And so that would then be kind of an offset that you often will see in contract cases at the end. This case was a little odd because, a lot of the litigation gets compressed to a short amount of time, and people have to argue about all the different parts of the case. And so the Tesla attorneys in this case, Mr. Musk's attorneys in this case, were sort of in an odd position of saying, hey, listen, this pay package is 100% fair. It was highly incentivized, but that was exactly what the design was, and look how well it paid off. It would be hard at the same time to say, oh, by the way, this was the fair and the unfair part, right? It's kind of hard to argue that the thing was entirely fair, and at the same time, you can distinguish between the fair part and the unfair part. And so I think the defense attorneys in this case sort of understandably decided to make a strategic choice of not even offering, some alternative valuation that's less than $56 billion of what the fair value of Mr. Musk's services was. But that ended up creating big problems for them once liability was found, because there was no alternative theory about what some sort of an offset should be for the fair value of Musk's services.
Another unusual thing about this $6 billion legal fee is that the lawyers are asking to be paid in Tesla stock. Another twist. Did that surprise you?
It is definitely an unconventional request. It was not surprising to me that they made a request of Tesla stock rather than money, in part because that is the very remedy that they were seeking. They were seeking the return of stock. And if you then want to translate that into what is 11% of the value of that, well, then you get another set of headaches about on what date do you value it, and how do you value some of these, options that haven't been fully vested yet, and maybe underwater or in the money and so forth. So that ends up setting up a huge number of valuation challenges that I think on some level the plaintiff said, look, we don't have to go there on the valuation challenges. If we had petitioned for the return of money, then we'd want 11% of the money. If we petitioned for the return of a bunch of shares, we want 11% of the shares. Now, on some level, that makes sense. I think it might also make sense from the business positioning right now of Tesla. It's still very, very valuable company, obviously, but the headwinds in the EV industry are now definitely strong, and so having the corporate sort of till invaded by a cash award that has to go out to plaintiffs' attorneys, that's a little bit harder still. Tesla could, in principle, just sell more stock and pay for it that way. But, on some level, even though it's unconventional, it just didn't surprise me to see that the request was being made for stock, which was the very thing that the plaintiffs were asking for the return of, rather than cash. Now, it does put kind of an interesting twist on what do you do if you were a plaintiff side firm who just has received a bunch of stock in a defendant that you just sued, and you're trying to, maybe build more business in the future, and some of that business might be now suing that same company for other things in the future. Well, now you're a big stockholder of that company. Do you really want to win? Because now it's going to hurt you in the pocketbook with respect to the stock that you own. So my sense is that even, if an award of stock is approved and is effectively executed on, the plaintiff's attorneys are probably going to be well advised to try to unwind that position through progressive sales of those stocks out into the market, so they are no longer basically, big stockholders of the company that they may end up suing again, possibly for how the company responds to this very judgment.
They'll be litigating this case for years to come. So I'm sure we'll be talking about it again, Eric. Thanks so much. That's Professor Eric Talley of Columbia Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.